Section 1 or Sri C.H.K. Bhupati Garu and Madam Rema Rajeshwari and Pagadala Ashok, and this session is going to chair by Honorable Justice Maushmi Bhattachary Madam, Judge, High Court for the State of Telangana and a chairperson of the committee to monitor the cases filed under POCSO Act, and at the same time JJC also. Now I request Honorable Srimati Justice Maushmi Bhattachary Madam to come on to the dais. And I request Sri C.H.K. Bhupati, Principal District and Session Judge, please come on to the dais, sir. And Madam Rema Rajeshwari, IPS, Deputy Inspector General of Police, Women Safety Wing, Telangana. Madam, please come on to the dais. Sri Pagadala Ashok, Additional DCP, North Zone, Hyderabad. Sir, I request you to come on to the dais. I request Honorable Srimati Justice Tirumala Devi Madam to present a sapling to my Lord Honorable Justice Maushmi Bhattachary Madam. And now I request Srimati Sunita Kunchala, Principal District Judge, Peddapalli, to present a sapling to Sri C.H.K. Bhupati Garu. I request Srimati Chatana, IAS, SP, Women Safety Wing, to present a sapling to Madam Rema Rajeshwari, IPS. Madam, I also request you to extend, Chatana ma'am, I request you to extend sapling to Sri Pagadala Ashok Garu. Ma'am, now I request the Honorable Srimati Justice Maushmi Bhattachary Madam to chair the session. I request all the participants to interact with the panel speakers on the topics assigned to this session. Thank you, ma'am. Please. Naresh.
Good afternoon, everyone. My most esteemed colleagues who are here, thank you very much for being here. And everyone else who's come back after lunch. I and my very specialized and esteemed panelists have an uphill task because we are here after lunch. So if not anything else, we will at least help you not to fall asleep, hopefully. So we have a very interesting topic today, which is convergence of the three legislations, namely the BNSS, the 2023, the JJ Act of 2015, and the POCSO 2012. What is convergence? I have a very short, I think about 8+2 slides PPT just to give an overview, and I will do that at an appropriate point of time. So what is convergence? And why is convergence necessary for the theme which we have today, the consultation, voice of the voiceless with special focus on a child? So when we think of convergence, we know that all these three acts, including I would say the Criminal Procedure Code, which has kind of joined hands on the statutory framework to protect the child and to keep a sustained focus on the child. Now, if we look at these acts, and apart from my colleagues, apart from my panelists, apart from all of you here, who have dealt with cases not only in the level of the courts, the district judiciary or the high courts, but on the ground level, as the arm of the law enforcement agencies, you will know that there are certain common objectives, common aims, which all these 4 statutes protect. For example, I can immediately think of about 5, 6. In-camera trials, identity protection, fast-track courts, immediate detection, no face-to-face confrontation, and of course, putting the child in a safe and a comfortable environment. So when I was looking at the 3 acts and I was thinking that what would be the points of commonality, what would be the points where the 4 acts come together, I broadly wanted to bring you about 4 heads. The first of which is victim compensation. The second would be fast-track courts. The third would be medical examination. The fourth would be early detection. There can be many other convergence points, but I thought that when the focus is the child, then these 4 would be extremely and immediately important to protect their privacy, to protect their rights. If you look at the object of the acts, of course you know that the Criminal Procedure Code, the BNSS, these are procedural laws. These will tell you where to go for redressal of your grievance, which is the court, and what would be the procedure after you go to the court. What would be the mechanism of the criminal justice taking over from the point of filing of the complaint. This is not a substantive law. BNSS, to an extent, of course, now it's a good mix of procedure and substance. But if you look at the JJ Act and the POCSO Act, you will find that what it needs to do, JJ Act, BNSS is sections 395, 396. Criminal Procedure Code, you will find section 357A, which talks of victim compensation. There are 2 important things to keep in mind. Number 1 is that the offender must pay, must compensate the aggrieved person, the person who has faced the offense, regardless of the offender's capability to pay. Very important. Number 2, the victim must be put to the position which the victim was before commission of the offense. So there cannot be, like we normally do in maintenance cases, so there cannot be a complete downgradation of the victim's position after compensation. So these 2 are important things to remember. And victim compensation, you will find that it has to be immediate, it has to be sustaining, and it has to bring the offender to book. I have about 10 minutes and I don't want to take up much time because I would like to hand over the talk to my much more experienced panelists. But if I go to the second, rehabilitation. What does rehabilitation do? You'll find that the POCSO Act contemplates rehabilitation for child victims focusing on their immediate needs. So it's not that, what the child will require 5 years hence or even 6 months hence, but what is the immediate need to rehabilitate? What are the social, the civil society forces to bring together to rehabilitate the child, to mainstream the child? You know that section 39, if I'm not mistaken, of the JJ Act, that speaks of rehabilitation. That is all about not only mainstreaming, but effective mainstreaming, so that the juvenile finds effective reconciliation with society. Next, I would talk about medical examination. Section 27 of the POCSO Act talks about medical re-examination and important things, medical examination, important things, that the consent of the child is very important. So if the child says, or if the child says that I don't want to be examined, then the next level is the parents. If the parents are not there, or if the parents are not available for whatever reason, then a medical board consisting of senior doctors, they can give an opinion whether the child should be examined, and if yes, how to conduct the procedure of examination. Next, if I talk about the JJ Act, it's not only about immediate examination, that is within 24 hours, but also the care and protection of the child becomes very important in that immediate medical care circumstance. Next is early detection and fast track. So under the CRPC and the BNSS, it starts with the FIR, which has to be promptly registered in with the police station. And the police officers will then be called upon to investigate cognizable offences under the order of a magistrate. And under 156(3), magistrates can also order investigation in certain circumstances, and including for unregistered crimes. Under the POCSO and the JJ Act, the incident must be reported immediately, so there cannot be any delay, just to protect the rights of the child. And the CRPC and the BNSS also provides for summary trials. I'll just quickly go to my next topic, which is the importance of age, which is the second subdivision of what we have to talk about. You know that under Section 29 of the POCSO Act, there is a presumption of guilt. And that presumption of guilt is entirely dependent on whether the victim is below 18 years of age. I think Section 2D of the POCSO Act defines child, and I think it's Section 221 or something of the JJ Act which defines a child. Everything, about below 18 years of age. So presumption of guilt actually under Section 29 requires the court to treat as the first foundational fact as to whether the victim was below 18 years or not. Because if the victim is above 18 years, then of course the entire mechanism of the criminal procedure trial, that changes, and there is no presumption of guilt under Section 29. But if the victim is of course below 18, then the entire presumption of guilt arises under Section 29. And then if you see from the POCSO, if you shift your gaze to JJ Act, you'll find that Section 15 of the JJ Act talks about presumption. It can be through visual appearance, it can be through interactions with the offender, with the or the child or the person who has suffered the offence with the JJ board. But it is actually Section 94 of the JJ Act which lists these three, I think Section 94 1 or 2, but it has these three ways of determining age. Number 1 is school certificates. Number 2 is certificates from the corporation, municipal corporation. And number 3 is the ossification test. And when I was doing a little bit of reading actually last night, I came across these this one technique which is being used now by the US immigration authorities. You know that there is huge thing going on under the President of the United States policies that immigrants should be sent back, etc. They've come across this test called the wisdom teeth test. And that wisdom teeth test is the third molar tooth, which usually sprouts between 17 and 25 years of age. And they feel that the margin of error in the wisdom teeth test is much lower than the bone ossification test. The second, the recent technique which I came across is called the epigenetic clock. The epigenetic clock test. that actually measures the age using the age of DNA and the age of, the methyl conditions of DNA, that how old is the particular tissue in the body of the victim. So can you imagine how advanced and how scientific these tests have become just in order to determine age. And under the POCSO, you know that it is so important to determine the age of the victim so as to not only sometimes protect the rights of the accused, but also to bring the accused under the book because of Section 29, the presumption of innocence. And in a 2022 judgment of, I think, authored by Justice Pardiwala, it's called Shubham Sankra 2022. I've forgotten the citation. There, the Supreme Court also took into account the ways of measuring of age determination under Section 94 of the JJ Act, read with Section 15 in some circumstances, and saying that, visual appearance of a child or visual appearance, how a person looks, cannot be a determinative factor, and it can be full of error, and therefore specialized tests must be developed to determine age. And the last, of course, I'll just one line on that, is the cyber crimes. You know that now children are, the biggest victims of cyber crimes, whether it's child pornography, whether it's, morphing the image and, using that particular child's face. And it is so quick, it is so heartless, and it does complete